Tonight on the Daily Debrief, more federal charges for Michael Avenatti. Also, the leader of WikiLeaks arrested in London. And
the failure is in their hands.
The defense accuses the state of failing to investigate the death of a 3-year-old Ohio girl. Plus, friends testify about a deadly stabbing which killed a college basketball player. The nation's most fascinating cases are on the Daily Debrief. It's Thursday, April 11th.
And good evening, everybody. Aaron Keller back with you again, along with attorney Jesse Weber and attorney Bob Hilla. New charges tonight against celebrity attorney Michael Avenatti. Federal prosecutors are accusing him of yet another series of crimes. Rachel Stockman reports.
The legal hits against attorney Michael Avenatti just keep on coming.
Celebrity attorney Michael Avenatti was arrested yesterday.
36-count federal indictment.
Avenatti is accused of stealing millions from his employees and legal clients and failing to pay taxes for the past 9 years in a 36-count indictment.
He is now the poster child of why people don't like attorneys.
Avenatti declared his innocence on Twitter following the accusations. He's accused of stealing nearly all of a $4 million settlement he negotiated on behalf of a paraplegic client.
To hide the fact that you have the settlement from a client is one of the most egregious things that you can do as an attorney.
Prosecutors allege he used most of the money on a private jet, which has now been seized by authorities. In responses, Avenatti tweeted a statement signed by his client on the case, calling Avenatti an exceptional and honest and ethical attorney. However, in the indictment, prosecutors allege Avenatti deceived his client into signing that same statement. They claim Avenatti told his client it was necessary for him to receive his settlement money. Avenatti skyrocketed to prominence representing porn star Stormy Daniels against President Trump for alleged hush money payments to cover up their affair. He was also charged 2 weeks ago with extorting sportswear manufacturer Nike in a completely separate case. For the Law&Crime Network, I'm Rachel Stockman.
Now to Ohio for closing arguments against a babysitter accused of killing a young girl in her care. Lindsay Partin is charged with murder, involuntary manslaughter, and 3 counts of endangering a child. Victim Hannah Weshy was just 3 years old. Partin was babysitting her when the little girl is said to have dumped ketchup in a toilet, which the prosecutor said was typical child behavior. But the prosecutor says Partin lashed out and, according to the local sheriff's office, she admits to hitting the child. The prosecutor mocked the defendant for thinking she would not get in trouble for admitting certain acts and for making up stories to explain the victim's injuries.
Ladies and gentlemen, she sat here right on the stand and she told you that she thought it was well within her rights to poke Hannah in the chest, to squeeze Hannah around the middle, to slap her with an open hand across the face, to hit her under the chin with a closed fist. And she even said she thought it was well within her rights to shake that child. I didn't think I would get in trouble for that. And what we can tell you, ladies and gentlemen of the jury, is what the defendant admitted to. And that the injuries on Hannah are consistent with what the defendant told you. And I submit to you that had detectives known to ask about that bruise on the back of the head, those bruises, had they known they were there, and they asked that defendant about it, she would have had an explanation for that as well.
The defense says the state failed miserably to investigate the child's father, Jason Weshy, as the source of Hannah's injuries.
They want to say, we don't know what happened. Well, whose fault's that? Whose fault is that? Do you have 33,000 pages of Jason Weshy's phone? Why not? Because they didn't ask for it. Lindsay gave hers up by consent. And then they got a search warrant also, which they didn't need. But what did they never, ever ask for? Jason Weshy's phone. And why would you find that important? Because what he did, where he was, and who he was with, and that means Hannah was with, is absolutely, positively important to this case. The failure is in their hands. it is the state of Ohio's burden of proof to prove beyond a reasonable doubt that Lindsay Partin did these things. We're talking about who, when, and those burdens lie squarely in the state of Ohio's hands, squarely. The defense has zero burden whatsoever. I could have sat in that seat, Mr. Pagan could have sat in his seat, and we could have asked not a single question. And I submit to you that if we had done that, you would still have all of the reasonable doubts that exist. All of them.
Earlier in the case, a defense doctor testified remotely that Hannah Wesche did not exhibit many of the telltale signs of a shaken child, such as bruising on the brain. The state forced that expert to admit some young children do not exhibit those symptoms, even when attacked. Also earlier in this case, the defendant herself took the stand. She insisted she did not hurt Hannah and that she was lying to protect other people, like the child's father.
Lindsay, did you cause harm to Hannah Wesche on March 8th?
I did not.
Did you cause harm to her on March 6th?
I did not.
Did you cause harm to her on March 7th?
I did not.
Why did you tell the police that you did?
Because I wanted to protect everybody.
And what do you mean by I wanted to protect everybody?
In the first interview, I felt like it was all about TJ. I mean, they even asked me if I was an abused wife, if he was abusing me. And I cared about Jason. I didn't want anybody to be in trouble.
Remember, the crux of this case relies on the idea that Partin may have hurt Hannah because she squirted ketchup into a toilet. If you go back to the police interrogation of the defendant, though, Partin admits to hitting Hannah about this kitchen incident, but on the stand, she said that's a lie she also came up with.
The ketchup. Remember the story you told the detective?
Yes.
Was the ketchup story real?
No.
Why did you say that?
Because Hannah and Vivian always helped me cook. The day before, we had mini corn dogs, and they were squirting the ketchup on the plate, and it was something that they had touched, that we had done.
Did you hit Hannah after the ketchup?
No.
Did you take her into the bathroom where she was squirting the ketchup and hit her?
No.
Why did you say you did?
Because I've had a friend, my friend Andrea, tell me that she's slapped her kid before and it's never been an issue. I just thought that would never be an issue. It's discipline. It wouldn't be anything that would get anyone in trouble.
On cross-examination, the defendant said she believed she could physically discipline Hannah, seemingly without consequences.
It's your testimony that on 3/9/2018 that you didn't know that admitting to shaking Hannah would get you in trouble.
No, I didn't think it would.
It's your testimony that on 3/9/2018 that you didn't know that shaking Hannah and that you didn't even know if she lost consciousness wouldn't get you in trouble.
No, I didn't think so.
You indicated that it was your belief you could physically discipline Hannah.
Yes.
Was it your belief, or did you think, Ms. Partin, that you could poke her chest?
I don't know if...
Ms. Partin, did you
There's an
think
answer
that
to that.
you could slap her across the face?
I have known other moms to do that.
That's not what I'm
So I
asking.
didn't think that it was an issue as a type of discipline.
That wasn't my question. My question was, it was your belief that you could physically discipline Hannah. Was it your belief that you could slap her across the face to discipline her?
Ask an answer.
It wasn't answered yet.
Thank you.
Yes.
Did you think then, was it your belief that you could squeeze her middle?
Yes.
Was it your belief that you could hit her on the face with an open hand?
Yes.
And was it your belief that you could hit her on the chin with a closed fist?
Yes.
And was it your belief that you could shake her?
Yes.
My guests tonight are attorney Bob Hilla and attorney Jesse Weber. Good to see you both here. So look, this is compelling testimony. Jesse, let me start with you here. Does the jury believe somebody who admits to being a liar?
problem with her whole case is she's feeding exactly into the charges. She's not charged with intentionally killing this girl. She's charged with abusing this girl, and it resulted in the death. What about what she just said is not arguing against that? I don't think so. I think she's creating a big problem for herself.
Bob, your analysis.
She's all over the place. But the time is so short that she had the child in her care, and that's pretty well documented. The injuries are so grave, again, they're very documented, well documented, that there's a question as to whether or not the defendant could have caused those injuries, maybe contributed, but whether the cause, that raises the possibility of the father as an alternative. Is that your reasonable doubt? I don't know, but that's what the jury's going to have to determine.
Jesse, that's where I wanted to go with this, because the defense raised a pretty serious, actually, let me throw it back to you, Bob, a pretty serious issue here with a failure to investigate in this case. And look, I mean, all the defense needs to do is raise that reasonable doubt, and the defense gets up there and says, wait a minute, the father had the child, as you said, you know, for a much longer length of time. Should the police at least have looked at the father a little bit?
I'm sure that's going through the jurors' minds. But ultimately, with respect to the case, they're going to have to decide whether or not he's a possibility for what happened to this child. And if they think that it's reasonable to assume that, they can reach a reasonable doubt, I think.
A lot of big questions in this case. We're going to move along to our next story here. Still ahead tonight on the Debrief. The Mueller probe resulting in charges against the top legal official from the Obama administration. Plus, the case of a college basketball player stabbed and killed. Did the defendant act in self-defense? We're back inside the courtroom after this. Welcome back to the Debrief, ladies and gentlemen. The founder of WikiLeaks has been arrested at the request of U.S. authorities. Julian Assange was taken into custody in London to face U.S. charges that he conspired to steal military secrets with former Army intelligence officer Chelsea Manning. Assange and Manning are accused of working together to hack a Department of Defense computer in order to access classified documents. Manning was convicted in 2013 of providing thousands of those documents to WikiLeaks. WikiLeaks made headlines during the 2016 presidential election after the site leaked close to 20,000 emails from Democratic National Committee staffers. A top legal official in the administration of former President Barack Obama has been indicted as part of special counsel Robert Mueller's probe. Gregory Craig served as White House counsel for President Obama. He's now facing charges that he lied and information about his law firm's work for the Ukrainian government in 2012. The firm was hired to write a report essentially justifying the then Ukrainian president's decision to prosecute and imprison a political rival. Now back to our trials here on the Law and Crime Network. The state is presenting a rebuttal case against a man accused of killing his daughter by throwing her off a bridge. John Johnchuk is accused of murdering Phoebe Johnchuk by tossing her into Tampa Bay, Florida. The question is whether the defendant is legally insane or whether he can be held criminally responsible. A state expert testified that in her opinion, Johnchuk, the defendant, was not legally insane and that he was making up symptoms related to mental health. Now to Iowa, where a man is accused of stabbing a college basketball player to death. Luke VanHemert is charged with second-degree murder in the 2018 killing of William Penn University basketball player Marquis Todd. VanHemert claims he stabbed Todd in self-defense during an altercation with Todd's teammate following a minor car accident outside the defendant's own home. The prosecution said it was the defendant who started the fight and ultimately finished it. One of the victim's friends describes the scene when it became heated.
Somebody came out of the dark with a rock. They threw the rock through my windshield, and then I hit the brakes, and then the defendant came with a pole and hit the driver's side window. In my head, I'm like, why would he do this?
Are you scared?
Yes, sir.
You mad?
Yes, sir. I was talking to the older guy, and I said, somebody in a Jeep hit my car. I'm like, who's gonna pay for it? And he proceeded to walk off. The defendant, he's coming from over here somewhere, and he comes charging and yelling at Marquise.
All right. What did you see? Did you see anything that he did when he came charging, as you say, out of somewhere on the left side of this house?
No, sir. I just noticed they started scuffling.
How long did that all last?
15, 20 seconds.
What caused it to stop happening?
Like we didn't come to fight. Like once like they were on the ground or something, like we was done. Marquise like screamed out like, "I think I got tased. I got tased."
Worse than that, the defense tried to get the friend to admit that he and the victim were the ones up to no good.
I was just gonna go get them, just in case they were there type stuff. Can you tell the jury what you would have meant by that?
I mean, I guess I would have meant like to confront them about what happened to my car.
The reality was that you weren't gonna let these two little punk county guys punk you out like this, right?
No, sir. But that doesn't. I mean, like that wasn't the reality. Like I'm saying, like I just wanted my car to get paid for it.
Okay. Well, if you would have contacted the police, does that make you less of a man for getting the police involved, or do you think you need to handle it on your own?
I don't really know how to answer that question. I just wanted to talk and see if they could just pay for my car.
How tall are you, sir?
6'6".
Okay. And how about Mr. Allen?
6'8".
And how about Mr. Todd?
6'9".
Okay. So 3 pretty big dudes, right?
Yes, sir. We play basketball.
Yeah. And you're getting out in front of this guy's house and wanting to confront him about this damage to the vehicle that, by your own account, was pretty nerve-wracking and frightening when all that happened, right?
Yes, sir.
Later, a police officer testified about what he learned from the defendant.
He advised that the male swung at him and then had pushed him to the ground.
Did he indicate that that person had any sort of weapon?
He initially advised one of the males was armed, he believed with like a tire iron, but he didn't specify that it was the male he was engaged with.
Did he mention that he might have had a knife on him?
No.
Did he mention that he might have used that knife?
No.
Did he mention that he actually, in fact, stabbed this person 3 times?
No.
Did any time during any of this conversation with the defendant did he say anything even resembling, you know, I had to stab this person because I was scared for my life, I was scared for the life of my father, I was scared for the life of my friends?
No.
No mention of self-defense in any way, shape, or form?
No.
The defendant's father is the one who called 911. It's a little bit hard to hear here, but he tells the dispatcher there was a group of people in front of his home acting aggressively.
Where are you at? 603 North 3rd Street. 603 North 3rd? What's going on? These black guys are beating us up. Black guys are beating you up? Yes. Do they have any kind of weapons? Yeah, one has Stacy something. One has a what? Stacy something. Stacy something? What's your name, sir? Hello? The what? What's your name, sir? VanHemert. VanHemert? Yeah, this guy, you know, told me that he's one of them was hurt too. I don't know what's going on. Did they give an ambulance? Yeah, but they didn't an ambulance. They got hurt, they didn't follow. They need an ambulance? What kind of injuries? What kind of injuries? I don't know. Okay, who's injured, a male or a female? They're all male. And they got Tennessee license plates. I'm sorry? No. They got Tennessee license plates. They got Tennessee license plates? Yes, they're from Williamson College. Okay, are they still there? They're leaving. They're getting ready to leave. Let them go. They're getting ready to leave with Tennessee license plates? Yes, they're going to ambulance, Jamie.
Attorneys Jesse Weber and Bob Hille are back here once again on the debrief tonight. So, Jesse, let me ask you this one. The friend, is he credible or is he not? He's one of the state's key witnesses, but he gets up there and on cross-examination, he's sort of asked, like, you know, if you're so worried about money, why didn't you just call the police?
That's a great point. In these self-defense cases, you see a lot of times the friends and family or people who were there, they obviously want to side for the person, either the victim or the defendant. You see that really, especially in these cases. Obviously, you have to pick apart that bias and think about, is what he's saying true? And this is a tough case from a lot of different angles.
I agree with that as well, Bob. So what do you make of the testimony of the friend and couple it with this situation? You've got some kind of a minor car accident, fender bender, whatever, there's property damage. Then people leave the scene, then they come back, and that key witness, the friend, the prosecutor wants us to believe that those big dudes, as he said, weren't going back to try to stir up trouble.
I think basically the real question here is that, well, one fact is no knife was brandished initially, so there was not intent to use a weapon. The stabbing happened during a struggle. So the question was, what was really going on here? They're going to be all over the place. This started as an argument, it escalated to a fight, and ultimately resulted in a killing. So the question is going to be who was the aggressor at that point, and whether or not the force that was used to respond to the struggle was reasonable.
This turns into a difficult question a lot of times because, you know, who was the aggressor? We ask that question. You have different viewpoints. We have questions about credibility of the friends of the victim who are testifying for the prosecution. So, Jesse, how do we unravel it all? I think it's, you know, when does the act of aggression start? Does it act when they go back to the scene? Does it act when somebody approaches somebody else? You know, when does the jury try to pick that apart?
I think in this case, there's a lot of people who are at fault. The question is, you have a use of a deadly weapon against somebody who apparently didn't have a weapon. The question is, when was that aggression necessary? When was that use of force necessary? It's hard to pinpoint who started what, but the fact that the victim and his friends came back to the defendant's house is a huge point for the defense, in my opinion.
We just have a couple seconds left. Bob, do you agree?
Agree.
Simply put, okay, well, wow, that was the shortest answer possible. Bob Hille and Jesse Weber, appreciate you joining me. Glad to be back here on the debrief with everybody.
See you in the chair.
Well, you know, and Bob, thank you for sitting in between Jesse and I, who trade barbs frequently.
Thank you very much.
That's all the time we've got tonight on the debrief. We hope you'll join us again tomorrow now that I'm back at the regular time slot here, 5 o'clock Eastern on the Law and Crime Network. Our live trial coverage begins tomorrow at 9 a.m. Eastern. You can watch these and the many other cases that we're following. We hope you have a good night, and we'll see you back here tomorrow.